All right, good morning, everyone. It is 9:30 a.m. on Wednesday, April 15th. Happy tax day. You got your stuff in on time. Moving forward to our first order of business, we have continued witness testimony on S-298, an act relating to creating the Vermont Voting Rights Act. And we have asked our friends from the AG's office to come back and have a deeper conversation with us on what we could consider including in the bill. Sort of the rough gist from last week was like the legislative intent was understood, but there was some nuance that may or may not need to be addressed. Should we choose to move forward with some of those conversations? So with that, I guess I will just ask our guests to join us. Yeah, no, totally. I kind of.
Is that okay?
Oh, absolutely. I was kind of anticipating it. So yeah, please feel free.
Good morning, everyone.
Morning.
I'm Leslie Wells, Assistant Attorney General. With me is Julio Thompson.
Morning.
Assistant Attorney General as well. As you know, but I'll say it for the record because I'm able to have that in every time we testify. I'm here in my capacity as chair of the AGO Internal Campaign Finance Committee that investigates allegations of not just campaign finance fraud, but elections fraud as well. So that's why I'm here to talk on that in that space. Julio, do you want to give more context for you?
Sure. I'm co-director of the Civil Rights Unit, and although our daily work doesn't involve voting rights, we are a proactive enforcement unit for various state civil rights laws. And so part of the lens that I'll be looking through today will be the pros and cons of different standards for enforcement so that people are carrying out the law as the legislator intended to be talking about.
So I'll start with, we came in last week and testified and, gave you a lot of context for the Federal Civil Rights Act. And I just want to get really clear. We do support the bill. Like, we are absolutely in support of the bill. And to that end, we have some ideas of how to address the concerns that we raised last week. The low-hanging fruit one is I raised the request for pre-litigation investigative authority. That would be consistent with what we have in the other context of elections investigations. For example, in Title 17, Chapter 35, offenses against the purity of elections. I don't know a shorthand way to refer to that chapter, but that's what it's called. When we're looking at issues where somebody might have been accused of voting twice, matters like that, we have this investigative authority thanks to S-23, the synthetic media in elections bill that is now law. We also have that same investigative authority in the campaign finance violation realm when we're investigating alleged violations of campaign finance. And so last night I sent some suggested language that is just cut and paste from the campaign finance chapter. I tried to make some tweaks to it where there's cross references to campaign finance law to reference the piece that we're looking at here in Section 2. So where I'm suggesting that we have this is in Section 2, because it's what Section 2 is doing is adding a new chapter into Title 17 that isn't already covered by Title 17, Chapter 35 or 61. So Chapter 59 would need to have its own authority or cross-reference to another section, whatever Leg Council prefers on that. I'm not an expert in drafting legislation, but I thought it would be easier. It's always easier to edit than it is to create. So I sent some language that I pulled from 61. So I think that's a very low-hanging fruit way to address that concern. It will, and what I testified about the rationale behind this request last week that I'll just remind you is it's to try to save money for everybody involved, try to save on resources, because if we can use these investigative tools to even determine whether there's merit, then we prevent, tying up the courts. We prevent tying up our resources and filing something in court. We prevent the person we're investigating from having to hire an attorney necessarily. I mean, they might choose to for the investigation, but it's different. When you're in court, it's a different level of, engagement, and most people feel compelled to hire attorneys at that stage. And it's more nimble. It's, we're able to kind of get to the heart of it pretty quickly, whereas in court, we have like protracted discovery sometimes. And even if we try to move it quickly, it's not by its nature a quick process. So this should help us move it forward. And it's consistent with how we investigate elections law in other spheres. So from a policy perspective, it's not creating anything new. It's not expanding our authority. It's just making sure that it's clear that it's consistent. So that's the basis for the recommendation about that. As for the other issues that we raised, I'm going to turn it to Julio in a second, but I want to just say that we raised a bunch of issues. And one idea about like, if it's not tenable to develop robust standards in this session, there's always an option of making some parts of the bill not go into effect immediately or by July 1, whatever the typical, I think the bill has effective upon, it's immediate effectivity. So that you can, I know you're well aware of this more than I am, but different sections of the bill could certainly have different effective dates. I think that the campaign expenditure section of the bill, so section 4, about expending campaign funds on security, that would be easy to do effective immediately. And I know that it's a policy concern of the Secretary of State, for example, to make sure that there's an ability for her to seek protection, understandably. So I think that one would be easy. It's not changing election law in an election year in a way that is difficult. As far as enforcing that campaign finance expenditure, I don't see it as terribly problematic. It'd be very easy to just add into kind of how we consider exemptions. Like, for example, candidates can spend campaign money on childcare while they're campaigning. So I would just view it through that lens, and that's no issue at all. So before I turn to Julio for more kind of details about the dilution piece in section 2, do you have any questions or want me to address anything further on the investigative tools?
Any questions at this time? Seeing no hands.
Okay.
Yeah.
All right, Julio, you want to
Sure.
talk a little bit more?
Well, I'm going to spend most of my time talking about section 2, the kind of the state version of the Federal Voting Rights Act. But before I dig into that, just to kind of go a little bit higher up in terms of looking at 298 from a broader perspective. So you have 5 sections. The title, that's section 1. 2 is the Voting Rights Act, and I'm going to spend most of the time talking about. Section 3 are those various interference offenses that are intimidation, false information, misleading people about voting times. Section 4 is security, and then 5 is the effective date. At least from our perspective, in the civil rights unit, relatively speaking, sections 3 and 4, that's the election misconduct and security, are the easy parts of the bill. I don't see, and again, I think we would defer to Secretary of State's always about electoral impact, because it is an election year. We're aware of that. And I think they'll have more insight on that. But from my perspective, in terms of what goes into effect first, those seem to be front of the line. Those are consistent with existing Vermont practice. Vermont has done this sort of thing before. And the language, at least to my eye, didn't seem particularly open-ended or problematic. Doesn't have a lot of unanswered questions. And so it's conceivable that you may, one path is that you have parts 3 and 4 go into effect sooner, and then 2 may go in later, depending on where and how section 2, the Voting Rights Act stuff, gets filled in. And I think and I saw on the list today that you're going to have some other folks who will be talking more on the policy. From the policy perspective, I saw at least there was an invitation for someone from the National Conference of State Legislators to talk about that. If you haven't looked at it, the NCSL has a great webpage about this that shows the 9 laws and that are already on the books, some dating back close to 10 years, as well as an examination of some of the bills that are pending in other places. I think that's very helpful. So it isn't like we have to start from scratch and we don't have to burrow into the federal case law in interpreting the federal law. We can look at what some of the states have been doing, and particularly some of the states who have had a little bit running time to implement their law. So I think that's a great resource, and I was really glad to see that. At least it appears that you may have a direct input from that office. I think that's very helpful. With respect to the Voting Rights Act section, again, the perspective, and there was a lot of information to cover last time, and I'm sorry, I talk fast sometimes. So if there's any point you think I'm going too fast or I'm not clear, please just interrupt me. For our office's perspective, it's not a question of whether we should have a state Voting Rights Act, because I think we emphatically agree with that. The question is what kind of state's Voting Rights Act that you have, because there are options. A lot of the other states that have enacted the laws have basically, through their own work on looking at, the way that the federal law has been implemented. And remember, federal law doesn't apply to just federal elections. It goes from congressional or federal elective offices all the way down to town votes on electing representatives there, or city councils and the like. And so what they've done is try to pick and choose, codify elements of the case law. It's clear that they borrow from what the courts have done for the things that they think work for their jurisdiction, because when you're talking about Voting Rights Act, you're really talking about the effect on communities of color, typically, and those with a limited English proficiency, and the demographics obviously vary widely from state to state. And so it's no surprise that some states with a different racial or language makeup have different laws and different ways of looking at it. Some, for example, when they're looking at populations, we'll look at not just let's say African-American voting segment, but also African-American plus Latino together, where it is a hybrid lens to look through in terms of voting opportunities. And that makes sense it makes more sense for some places than for others. I had mentioned last time that the Senate GovOps committee had looked at a version 1.1 of the introduced bill, 43-pager. I brought it here. That basically, tries to fill in what the criteria are. Like if we were to look at, or if a court were to look at a claim of voter dilution or vote suppression, what factors will we look at? What factors could we not look at? And that is one feature of a lot of these state voting rights acts, is that they provide kind of a do list and a don't list. And they don't all line up on what the do's and don'ts are. But they do provide, I think, crystal clear guidance for towns, localities, as well as courts in our office in making a determination about what facts are relevant and what are not relevant. And I think that, helps inform decision making at the local level in terms of what kind of assessment are we going to make before we implement and vote on something in the first place. And then if something comes to our attention, how we're going to evaluate that. Some of them can be quite numerous. One Voting Rights Act that I spent a little time recently looking at was the Minnesota Voting Rights Act that was enacted in 2024. There are other ones, like I said, there are 8 others, but I just happened to spend a little bit more time on the Minnesota Act because they had some features that I hadn't mentioned in my prior testimony. So Minnesota, like one feature of the Minnesota Voting Rights Act, which has these, you may consider, list of factors, and you may not consider, or you shall not consider factors. They also have a mechanism relating to lawsuits for private parties as a private right of action. And I think this bill also contemplates a private right of action, which historically has been the driver of change in voting rights has been private rights of action. Typically class actions brought by, say, NAACP, Legal Defense Fund, and other organizations. That law creates, in a way to reduce litigation backlogs and expenses, has for private parties a pre-notice or pre-lawsuit notification requirement. So if some voter or some group of voters think that there are inequities in the voting process, or something's going to create dilution or suppression in any way before they go to court, they would have, I think, the option to always to notify our office, which may investigate it. But in addition, they would have the right to go their own path if they wished. In Minnesota, before you do that, you have to notify the jurisdiction, say a letter to the town that identifies the concerns, and then give the town 60 days to cure it before you can go. And the idea behind that, at least in the Minnesota law, policy behind that was to try to get people to remedy things informally outside of a formal legal process. That's a feature I didn't mention before. I can see some benefit to that. It's just a question, I think, for you and the committee and other stakeholders, as whether that is something that would be suitable for Vermont. The flip side of that, and I think there may be, a desire to have some exemptions, is that some of those election issues may only come to the notice of people relatively close to an election date or a deadline. And so 60 days may be too long for them to go to court. They may learn about, or there may be some last minute change that people think is palpably going to affect voting in that jurisdiction. And then people may want a shorter path to go to court to get at least a temporary order to preserve the status quo before a new change goes into effect. So that's one thing we would be looking at, is whether you want to have that kind of pre-suit notice. From our standpoint as state enforcers, if we're investigating something, especially, of course, if you give our office those investigative tools, the civil investigative demand, which allows us to do our investigation without having to go to court, as a matter of practice, we're already going to be in that position. The civil rights unit where I work in, we've had civil investigative demand authority going back more than a generation. Most of our work, when we're in that investigative role, is done through the administrative investigation standard. We have early mediation, so even before we start investing resources, we give the respondent or the employer or whoever is responding to our investigation, we give them an opportunity to talk with us. If they have something we think is unlawful, they can cure it right away, and that may be the end of it. Sometimes it's even less formal than that. We call it in our unit phone law, where we call someone up and say, Vermont does have a Parental Family Leave Act. It does seem to apply to this individual. Do you have legal counsel that we can talk to? And they say, oh, no, it's a big misunderstanding, and things resolve. Those informal tools and those administrative tools can be very valuable from a state enforcement standpoint. Our unit rarely goes to court. When we indicate that we've done our investigation and we tell the responding party that we think we have identified a violation, usually the matter resolves. And that's the least expensive and the most time effective way to do it. Litigation, as you know, being government operations business, that where the courts are in Vermont. So that would be one area to look at. I think in terms of other areas to look at is to identify or pick, because I think you have your choice from version 1.1 and from other states, the sorts of remedies you think would be appropriate for a judge to adopt. One could just leave it to the discretion of the judge, and that's a policy choice. But I think it's instructive to look at, because I think a lot of us aren't thinking, like, if you have a question of voter dilution, how do you solve it? For example, you can have something where a town has an at-large election, and historically the voting is racially polarized. So maybe the voting minority group tends to vote for candidates of a certain party, and they're always outnumbered. And so, one remedy for that kind of, ongoing imbalance in voter power, would be to consider whether, if there are elected seats, instead of electing all of the city council seats, you have districts like you do in many towns where you divide it up. And so there are more opportunities for people to put in more candidates rather than just a voice vote. Today, as I sit here before you, I don't have like our preferred list because I think you have other people who are more subject matter experts from the stakeholders and the Secretary of State's office. But I think identifying potential remedies, it also gives us guidance so that if we are starting on an investigation, we know what remedies you think are fair play and which are not. And I think ahead of time, towns, when they're deciding what to do, they may be looking at, when they're debating whether they're going to make, or have a particular voting process or practice, they may, their town or council, or if they're working with council from the League of Cities, they can look at those remedies and see what other alternatives do they have if there is going to be an issue. And so the idea of just people knowing ahead of time what the rules of the road are gives them a chance to stay out of trouble to begin with, and also makes pre-litigation remedies very palatable. So I think that's an important feature of it. I've been talking for a while, hopefully not too fast. I'll stop if there are any questions about what I've said.
Any questions at this stage of the year?
No.
So I know Rep. Waters Evans is taking extensive notes, but yeah.
I sure am.
Yeah.
Could I just add,
Yes.
just to put a finer point on it, we really defer to the Secretary of State's office when it comes to policy matters on this bill. I mean, aside from investigative tools where we're probably better positioned to speak, but all of these kind of concepts about what we're going to be thinking about enforcement are policy matters for the Secretary of State's office. Obviously, ultimately you, but I defer to them when it comes to weighing in on those matters from the state. So thank you for inviting us, and happy to help brainstorm as you shape how you want this bill to look. Happy to offer language or review drafts, of course, anytime. But we're here to help, and sometimes it's hard when we bring up a lot of issues that we're seeing with it. It can be a little at least I'm overwhelmed sometimes when I'm dealing with that in my personal life. I'm like, oh, I have to come up with a plan. I need a plan. I can't feel confident until I have a plan. So we're here to help you as you develop your plan, and please don't hesitate to contact us. I think I saw a hand anyway.
Yes, Rep. Waters Evans.
It wasn't more of a question. It was just saying, when, hearing you both speak about this, it seems like I think generally don't want to speak for everybody in the committee, but I think in this case, I think we probably all agree that we don't want to create a law that's difficult to enforce, or that it's going to cause more problems after we create it. So your input is valuable, because, we want it to be enforceable and reasonable. And so these are good things to think about as we move forward. Thank you.
I just want to say I appreciate the quick turnaround time on us asking for more feedback. So that was very, very appreciative.
Happy to do it.
Cool. All right. Any discussion from the table right now on any of this? Y'all are free. And any thoughts on this piece right now? Okay, go.
I just would love to know how Senate GovOps got from the introduced bill to through several drafts, and each draft was dramatically different than the other draft. And I just really don't know how we got to where we are, but I feel like this would, notwithstanding the language that was just suggested, is a pretty simple, straightforward bill that mirrors federal law. And I understand the language that was suggested that could be inserted into this would give the same investigative authority as the AG's office already has for other portions of elections laws. So that sort of makes sense to me that they would be given another opportunity to do pre-litigation investigation. But I'm just at a loss as to how SGO got to what they sent us.
Grab water's ends.
I had an informal conversation in the cafeteria with a member of Senate GovOps who told me that there had been some, there were, as we do, we have a lot of ideas and then you get testimony and then there are concerns that are flagged from what they had before. I wonder if they would be willing to come in and talk about that a little bit. They might be able to come see us and give
The
some
reporter of the
testimony.
bill, perhaps?
Yes, perhaps the reporter. of the
Because we
bill,
did have the
because-
bill's sponsor.
That's
We have
right.
Yet to have the reporter.
Right, so that would be good, but what they had indicated to me was.
I can have a note there.
Yep. Oh, like, we're on the same page. It's getting
Swimming,
scary over
same
here.
direction.
Is that a lot of it were concerns from town clerks and some other folks who are thinking that it was not going to be feasible at this point. So, but I'm sure they can come give us
Okay. And I think that
a lot more
might be,
information about it.
I think that may be good for, one of the slots we have open later in the week, because we also have a conversation about this later this afternoon after the floor.
Yeah.
So I think that'll tee up a lot of the things we want to understand better once we're done. We
Yeah.
completed this testimony and then we have that after the floor. So we'll regroup at that point with clear
Yeah.
focus on this direction.
As someone who had a bill once that was 62 pages and then that passed as 9, I feel their pain, but also remember how, things happen and it's sometimes it's better to just get something concrete, but
Sometimes
small
less is
done.
more.
I know, it's so hard. But anyway, yeah, 8 pages down from 42 is pretty significant. So
Yeah.
that would be an interesting history to have. I just want to make sure that we are very clear when we have Senate GovOps come in or the bill reporter, that we're not, sometimes I get confused about what was in it and isn't anymore and how, and I just want to make sure that we're all clear when we talk to her about what remains,
Mhm.
because things can get muddy pretty quickly.
Understood. Rep. Nugent.
No. I don't know if this is a good question to ask now, but I'm curious about how this interacts with each 541 and or what the paths are for both of those. Are they gonna merge?
Where is 541 now? Is it in?
That is in Senate Judiciary.
Judiciary.
And yes,
Could we hear from them perhaps as to the intersection of these two bills?
we have a side by side on that.
Yeah.
Yeah,
But
And I think that, well, it was our House Judiciary bill, so I think it would, if we want to hear from somebody from a judiciary side, I think it would probably be best to hear from someone there. I believe, if I remember, the reporter was,
out of
we'll
here,
look that up, at a judiciary side.
Rep Goodell.
That's what I was trying to, I had the face, didn't have the name.
Yeah.
Sorry, Ian.
um,
Rep. one.
Is it, do we know, is it be considered in Senate?
I had a informal conversation with the chair of House Judiciary about including it here. And that was my recollection of that conversation was like a time management thing, possibly for Senate Judiciary because of work. And this is an appropriate home because there was mirrored language.
Yeah.
Grab water's ends.
When we were working on 841 earlier, I remember there was the animal welfare bill that we worked on. There was an animal, there was something to do with animals, but it was in judiciary because it was like animal cruelty related.
yeah.
And I remember Ledge Council telling us that when they have two similar bills or that have similar language or are trying to kind of control the same thing at the same time, that they keep an eye on it to make sure that the language isn't contradictory. And that as it moves forward, because what if one doesn't end up making it and the other one does, so that it's okay to have two moving through the process at the same time and that they have an eye on it. So maybe that's something we could just ask Ledge Council just to double check that they're keeping an eye on it. But I'm assuming that they are.
Never seen anything.
What's that?
Never seen anything.
Yes. Right, which is, like I said, I assume, but we should also double check.
This is Tim's bill, correct?
Right. Anything else? Okay, we will reconvene at 10:30 for testimony on S206, an act relating to placement of early childhood educators by the Office of Professional Regulation. All right.